Okay, Carl and Peter. I don't know, Larry, if you can hear me, we're starting back up. Item number 16, 10 Valley Mead Road. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, an arborist report prepared by Jordan Baker, supporting materials by the agent, Samantha Eby, email correspondence from traffic planning, as well as Ravine Natural Feature Protection and the TRCA, and none of them have any concerns. We have correspondence in support from number 37, the Palisades, 51436 and 8 Valley Mead Road, and I'm not showing any speakers in opposition. Okay, do I have the agent on the line?
This is Andrew Batey-Shorba,
Hi.
the architect.
Hi. Panel members, do you need a presentation?
No.
Okay, we don't need a presentation, sir. Let me see if there are any questions. Any questions, panel member? Mr. Nipfel?
Very simple. I noticed that you've got support from number 8 and 14. Do you have number 12 as support, which is an adjacent property, or have you had discussions with them?
Yes, the owner has had several discussions with them. They just declined to write a letter.
Okay, thank you very much.
Absolutely.
Any other questions, panel members?
No.
Okay, sir, we're ready to go into committee to make a decision. We've read all the materials. Is there anything you'd like to add that's not in the submissions before we go into committee?
Nope.
Okay. Panel members, any comments? Mr. Nipfel?
Madam Chairman, this is a very comprehensive submission, and I thank the applicant for that. I don't see any difficulties with this application. We have reports from Transportation, Ravine Protection, RCA. No one has any concerns, so I would like to move approval of the application subject to no conditions at all.
All right, do I have a seconder? Okay, Mr. Reed. Okay, motion to approve, moved by Mr. Nipfel, seconded by Mr. Reed. All in favor? The application's been unanimously approved. Item number 17 was deferred. Item number 18. Okay, 150 Harbord Street. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, a photograph of the subject property, as well as a covering letter from the owner, Mr. Zukowski, presentation materials submitted by the applicant. We have email correspondence from traffic planning. They don't have any concerns, and forestry is asking for condition number 2. Do I have the agent on the line?
Yes, hello? Can you hear me?
Yep. Can you please identify yourself for the record?
Yes, thank you. Good morning. Good afternoon. My name is Linda Hershkovitz. I reside at 97 Burnside Drive in Toronto.
Okay, thank you. Panel members, do you need a presentation on this one? No? Do you have any questions for the agent? Mr. Nipfel?
Yes.
Are the bicycle and parking conditions existing?
Yes, they are. If you see the drawings of the building or the photograph, the building occupies virtually the entire lot. We just have a narrow right-of-way on the east side and the west side going to the back, and there's a small open area in the back that provides access to the rear door and the fire escape or rear entrance. So as far as I can see, there's never been parking, and there's simply no space for it. We would be able to create bicycle parking at the rear of the building, and there are also those public rings, on the sidewalk actually,
Yeah.
in the front for bike parking. I also wanted just to say in regards to parking, if you don't mind, that the use that's being proposed, previously the building was occupied by a pub, that was 2 stories and generated quite a bit of traffic. It was very busy. They vacated, they moved down the street before the building was put up for sale. And the use that's being proposed now will generate far less traffic. We don't see that there's much need actually for parking, and there's certainly ample street parking where that would be necessary, and the same for bicycles.
Thank you. Panel members, any other questions? Seeing none? Okay, we're ready to take it into committee. Is there anything else you want to add that wasn't in the materials? We've read all the materials, so we're ready to make a decision on this.
Right. I don't think so. Just that we've owned the building since last December, and we're really keen to move forward. It's been sitting empty ever since while we wait for approvals and permits. So we'd really appreciate the opportunity to move forward with this on behalf, especially of my son, who's very keen to his studio and begin his career in this new location.
Okay. Panel members, let's take it into committee for a decision.
Chair, I'll start as someone who may have on rare occasions been in that pub. Sorry to see it go, but I really like this proposal. I actually think it's a great reuse for this building, and having additional rental accommodation and proximate to U of T, I think is also a very good thing. I don't have any problems with this, and if my colleagues don't, I'm happy to move a motion to approve, subject to forestry condition number 2.
Okay, do I have a seconder for that motion? Mr. Nipfel? All right, motion to approve, including forestry number 2. Moved by Mr. Clay, seconded by Mr. Nipfel. All in favor? Okay, your application has been approved. Okay, final item this morning, item number 19. 20 Vesta Drive. We have before us a copy of the plan of survey, revised site plan, floor plans, and elevations, covering letter from Amber Stewart, the agent, as well as presentation materials. Is Mr. Bronskill speaking?
Just to note, the letter from Amber Stewart, she's representing 2 neighbors. She's not the agent for this file. That's David Bronskill.
Right. Okay, thanks. Are you there, Mr. Bronskill?
Yes, Madam Chair, good afternoon.
Are you the one, you're the one speaking then, not Ms. Stewart?
Ms. Stewart's here as well, Madam Chair, on behalf of the neighbors, because subject to any questions, obviously the committee may have on the application itself, we're actually here on a joint basis asking for the committee to impose some conditions on the approval because we have overall worked out an amicable resolution between the 2 neighbors with Ms. Stewart's help and frankly the good faith nature of our clients, and therefore there are some conditions of approval that I think we would jointly want to speak to the committee about. But before we got those, I think I would be remiss, Madam Chair, if I didn't say we believe obviously the variances meet the 4 tests, but I'd be happy to answer any questions that the committee may have before we talked about the conditions.
Yeah, that sounds good. I don't think we need a presentation, so let me see if, do any of you have any questions before we get into the conditions for the 2 adjacent neighbors at 18 and 22? No? Okay, Mr. Bronskill, I think that the members are good with all the materials provided, so we know the application, so let's just deal with the conditions you're looking for. I mean, I did read, I understand something else was submitted that didn't get to the committee members, but from what I read from before, the only one that I think was imposable was screening. But if you can just outline where you're at now and what conditions you have that we in fact can impose.
Yes, so, and Ms. Stewart, Madam Chair, to be fair, may have some comments for you as well. So Ms. Stewart did helpfully submit some conditions. We have then worked on them after receiving that letter, and our apologies in this virtual session for not being able to provide them to the committee and committee staff in advance. Normally, I think in the pre-pandemic days from so long ago, we would have handed you an updated list to make it so much easier. So our apologies. The conditions that Ms. Stewart requested, I will make submissions that, in fact, I think where we are now, they are conditions that the committee could impose, but Ms. Stewart will also speak to them as required. What we're asking the committee to do first is a condition that the proposed dwelling be constructed substantially in accordance with certain plans, subject to certain revisions. And I think that's a condition Ms. Stewart proposed. There's no change to that condition, and I think that's a standard condition that the committee can and should impose. The second, we've revised what Ms. Stewart had requested in terms of certain window wells. And the language that committee staff now have would be that the building permit plans would ensure that the 3 window wells at the basement level be covered by a metal safety grate. And that's just to ensure that those window wells are safe in terms of the relationship. And I do think that relates to the construction and is something that the committee could impose. Related to that, we've also included that the building permit plans would show that the retaining wall that currently encroaches into the municipal boulevard would be removed. And that's to ensure appropriate access onto the adjacent dwelling at 18. It's something that is acceptable to my client. So I think that condition, Madam Chair, again, it relates to the building permit plans and is something that could be imposed by the committee. The third condition relates to screening on the rear 3rd floor balcony. The only change is we realize, subsequent to Ms. Stewart's letter, that it should refer to the north and south sides of the rear 3rd floor balcony, not the east and west. So we captured that change in the condition that has been brought before the committee. Next, Madam Chair, there are some conditions related to trees, and what we have done on the revised set is simplify them, and it would require my client to apply for a permit to injure or remove city-owned or privately owned trees, and have appropriate measures to ensure the protection of a city-owned tree adjacent to the front yard, and appropriate measures to ensure the protection of trees on the adjacent properties. Again, we think that's a condition that would be within the wheelhouse of the committee to impose. Condition 5 has been deleted. That is one that may have caused you some concern. So we would not be seeking that condition any longer. We are still seeking a condition relating to the location of the air conditioning units, that they would be on the north wall. That is something my client is prepared to do through a private agreement, but we do think that ensuring the air conditioning unit is located on that north side is an appropriate condition within the jurisdiction of the committee in terms of ensuring compatibility and mitigate noise impacts. So again, I think we do think that's a committee condition that can be imposed. There's then a condition requiring restrictions on how a new fence can be located. And again, I think we believe that's a condition that the committee can impose, and I've seen imposed by both TLAB and the Committee of Adjustment previously. The last condition that I would just speak to is one that may cause the committee some concern, but Ms. Stewart can speak to it as well. We think it's one that relates to the building plans. We've simply added a condition that the building permit plans would include all measures necessary to ensure that there's no damage to the existing driveways on the adjacent properties at 18 and 22 Vesta. And Madam Chair, the rationale for that condition that we've proposed is there are some grading changes on the property. I think if you look at any of the photographs, you can see the grade changes, you can see the relationships of the driveways. And it's just to ensure that when the building plans come forward, building permit plans come forward, that they've appropriately addressed that relationship between the driveways. Again, we think that relates to the plans. We think that's something that the building department can certainly enforce. And so we think it's an appropriate condition to approve. That would be the list of conditions that revise, Madam Chair. I'm happy to take any questions. And obviously, Madam Chair, it may be appropriate to hear from Ms. Stewart on those conditions as well. I want to make sure that she has the opportunity to speak.
Okay. I guess I'm just going to go to Madam Deputy Secretary Treasurer for 1 minute. Madam Deputy Secretary Treasurer, in terms of the forestry condition, I'm just trying to find one of the reports that has a general condition. Is it number 3 that we could impose, or that would cover the trees?
So the difficulty with imposing a condition from a division that hasn't asked for it, like forestry, and I've experienced this with forestry in the past, is that applicants have a difficult time in obtaining a clearance because they did not ask for that condition. So that's why I'm cautioning that that may not be an appropriate condition, because Urban Forestry has reviewed the files on today's agenda and they did not request any conditions for this application in particular. Most of the other conditions are also issues of a civil nature that an agreement can be made between the applicants, but they're not necessarily appropriate for the committee to be imposing. They don't relate to the variances, and they're not exactly easy to fulfill. For example, the restricting someone's ability to build a fence, that's not even a zoning issue, that's a municipal code issue, and the committee can't restrict someone's rights. If that's something they choose to agree on between themselves, that's different, but the committee should not be imposing those conditions. The only condition that seems appropriate is the one about the privacy screening. I think it's listed as number 3 in your package.
On the rear third floor balcony?
Yeah.
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 And the one for the construct substantially in accordance to plans submitted would work, but I think I heard something about revisions, so I'm not really sure how that can be applied.
Yeah, because they're asking about things related to window wells. Those aren't, if a window's permitted based on the building permit and then building code, sorry, about zoning and building code, then there's really no restrictions the committee should be imposing. And I'm not entirely confident that even when plans, if there's a condition tying it substantially in accordance with the plans, building could look at it and say, in their opinion, it's substantially in accordance. It's their determination, so I'm not sure that this may capture that. Usually when you're tying to plans, it's to ensure that if the building has an odd shape, that the depth, for example, isn't for the full width of it, or if height has dormers or certain varying heights, that it's built in accordance with the plan so it doesn't turn into a big flat roof, for example. So those are usually the reasons why the committee would tie to plans. And like I said, most of these are issues that are civil matter between the neighbors themselves, not for the committee to impose.
Okay. Mr. Bronskill, is there, I mean, if, are you able to not capture these things in a private agreement?
We can, Madam Chair, capture them in a private agreement. I do think, if I go back through the conditions, I do think building substantially in accordance with the plans is appropriate, and Ms. Stewart may want to comment on why they requested this, but it includes the locations of the balcony, it includes the windows and doors, and as part of the rationale for this application, there is a portion of the length or depth that goes to the back of the unexcavated, of the excavated deck, not unexcavated, my apologies, to the back of the unexcavated deck. So there is a below grade portion of this that seems to be appropriate to be restricted. So I do think that condition is appropriate. I also think the window wells, in terms of ensuring, and the retaining wall, they're part of the overall construction and development. And so I think those two conditions for sure. I also think the privacy screens, as the Deputy Secretary Treasurer noted, are acceptable. We're prepared to accept the condition related to trees and deal with urban forestry. I already gave you comments on the air conditioning and fence, why I think they're related to the plans, and I think they would be shown on the plans in terms of issuing a building permit. But if the committee sees fit not to impose those, we do have our commitment to include them in a private agreement.
Okay, I just want to clarify, just to go back to the substantially in accordance with the plans submitted. You're right, we impose that condition on a regular basis, but I heard additional wording about revised plans. So if we tie to plans, it's whatever we have before us, right? Well, that's where the confusion was with that one.
Yes, because the proposed condition says tie it to plans, but subject to further revisions, which the committee doesn't have. And those plans wouldn't show those revisions that are before you today.
Sorry, Madam Chair, I stepped away for a moment because my dog was trying to
Oh.
eat my phone. I apologize.
Well, you
I
gotta
apologize to
keep
that literally was the high school excuse. So the plans themselves aren't revised, so the proposed dwelling would be constructed substantially in accordance with the plans on file and dated June 17th. What we did with the second condition with Ms. Stewart is just ensure that there are two noted revisions to those plans, which would require the plans to show the 3 window wells at the basement level with safety grates, and would require the plans to show removal of the retaining wall from the municipal boulevard. So those would be the only 2 changes. So you're tying them to the plans that are before you, but then saying the building department, there are going to be 2 changes, and it relates to the window wells and the retaining wall. So I think it's clear and predictable and enforceable by the buildings department.
I know, but you can't tie to plans and then expect there to be changes to those plans. It's one or the other.
I just respectfully disagree, because we're tying them to the plans, but we're specifically noting the 2 changes that would be made to those plans. That's the way we've drafted the condition with Ms. Stewart's help. We're saying, subject to these 2 things, build substantially in accordance with those plans. Those 2 things are safety grates on the window wells and removal of the retaining wall. So it's very clear what those 2 revisions are that the building department would have to see.
All right, well, panel members, let's see if are there any other questions, panel members? Because I think we're just dealing with these requests here in terms of Mr. Niffel.
Maybe I missed something, and I understand what the concern is. It doesn't seem to me that the grates on the basement windows are part of the plans anyway. There's nowhere, unless I'm missing it totally.
No, but hang on, Carl, the issue is that they want to tie to plans with a provision in there subject to further revisions for putting.
No, I understand
putting, right?
that, but
So-
I don't have trouble with tying it to plans. I don't know that the plans, I don't know that there's a conflict in tying it to plans, and then the issue about the window grates aren't shown on the plans anyway.
You still there? I don't know, it's quiet.
I can hear you, but I've lost you.
Oh, okay.
I'm here, sorry, was that a question to me through you, Madam Chair?
Well, I think it was a comment from Mr.
Yeah.
Nipfel, basically saying that the grates wouldn't be showing on any plans anyway, was his comment, so
We
that,
would put them on the site plan with a note, through you, Madam Chair, to Mr. Nipfel. So on the north side, there are 3 window wells. We would ensure that those window wells have a note on them that show that there's a metal grate being required.
Okay, but that's not on the plans now.
They are not, sir, and that's why we're making it a specific requirement that would be a revision to the plans for us to get a building permit. I hope that helps.
Yeah, it does. It's still a problem, Mike. And the other question I had was, I didn't understand I missed it because I lost connection. I didn't understand your condition number 8. And it's not that you didn't explain it properly, I lost your sound.
Oh, thank you, sir. I think that's the one we were adding because we were deleting one condition, so there would still be 7, but it's the last one, and it relates, sir, to that the building permit plans would include all necessary measures to ensure no damage to the existing driveways on the adjacent properties. That's a condition being requested by Ms. Stewart on behalf of her clients. I don't know whether the committee would like to hear further from her on that or not.
well,
Okay, thank you.
I think that's more of a civil thing. I really don't think that's something the committee can impose. I mean, there's nobody that's going to, from the city, that's going to be able to go and inspect to make sure that there's no damage to adjacent driveways. It's just not practical. So I don't think it's enforceable.
So Chair, I think I'm just struggling a little bit with the conflicting kind of perspectives on this, whether we can attach conditions or not. And I guess in my mind, there seems to be an amicable agreement between councils for both parties. And I'm wondering why they can't just simply come to an agreement between the two of them and have something that's legally binding and allow us to just deal with those conditions that staff are suggesting are most appropriately dealt with by this committee. I get why you want to have conditions imposed by the committee, but it seems to me that if councils are in agreement that a fairly simple legal document between two parties would suffice. I just as a comment.
I think Mr. Bronskill did indicate that this can be all captured in a private agreement, and based on my experience and what the Deputy Secretary Treasurer has said, I think the only condition that we can really put on there that's enforceable is the rear third floor balcony, north and south side screening to 1.5 meters. Because even the substantially in accordance to plans, we could put that on, but it would only apply to what's before us, not the window wells and the retaining wall.
So if that's the case, then maybe do we want to go back to the agents and confirm that, or do we want to go straight to a motion?
Well,
we still have to hear from Amber Stewart.
yeah, we still have to hear from Amber, but I think that, I mean, if I'm wrong, I don't know, maybe before we go to her, I think we all agree that it's really, we can't impose all these conditions that are being requested. Mr. Nipfel?
The one that I would be inclined to still include is the one about substantially in accordance with the drawings. As Mr. Bronskill indicated, those drawings are capturing some form and design decisions that it might be wise to have solidified through those plans, notwithstanding the fact that it doesn't deal with grates to basement windows and so forth. And if, according to Larry's comment, if that could be dealt with between the solicitors, fine. But I don't see a difficulty in containing a condition to tie the approval to plans, because that condition addresses more than window grates. It addresses, as Mr. Bronskill indicated, the form and massing of the building, which may, in fact, if it's not there, might generate more concerns.
Yeah, agreed. So it's those two conditions, but that condition would be with the understanding that it does not capture the retaining wall or the window grills. So
Yeah.
those are the two conditions. Construct substantially in accordance with the plan submitted, as well as the screening on the balcony. Okay, so
Agreed.
with that agreement, let's then go to Amber Stewart.
Thank you very much. Good afternoon, everyone. So I thank my friend, Mr. Bronskill, for working with me on behalf of my clients to come to an agreed set of conditions. And I have to urge upon the committee that it would be very important to my clients to avoid any further appeals to have these conditions imposed. And, you know, I certainly understand the committee's comments, but I will start by saying that there is very broad latitude under the Planning Act, under Section 45, to impose conditions that the committee considers are advisable. I have certainly alerted to my clients to the fact that it is only practical and appropriate to include conditions that are reasonably related to the proposed development and also clearly enforceable by the city and clearable by the city. And I believe, and I think Mr. Bronskill agrees, that we have come up with a list of revised conditions that satisfy all three of those tests. I have heard the committee's concerns about the concern with imposing a substantially in accordance condition and then qualifying it by saying that certain additional in my view, very minor revisions will be made to the plans that go forward for a building permit. To that point, just to give an analogous example, I have seen many comment memos from, for example, engineering services staff that have indicated that a revised site plan must be submitted that satisfies X number of things. That's almost become a standard condition, such as not showing below-grade driveways and adding annotations to the site plan. In my view, those qualifications in condition number 2 are quite similar to that. It's simply that we wish that the building permit plans show 2 very minor revisions that can easily be accommodated and easily be cleared. On the note of condition number 1, I will indicate to the committee that it is absolutely critical to my clients that we have that substantially in accordance, and the language that we have proposed specifically references, including with respect to the size and location of all windows and doors and the 3rd floor rear balcony. And it is important to my clients that we have that massing and that articulated building envelope secured through that condition, together with the size and location of the openings. I think the privacy screens, I don't think there's any disagreement on that condition is easily imposed. With respect to the tree condition, I've heard the comment that it wasn't something that was requested by Urban Forestry, but I believe Mr. Bronskill and I are in agreement that it is clear that an application for a permit to injure will be necessary to Urban Forestry based on the plans and their proximity to the tree protection zones. And that includes, of course, a tree that is situated on my client's property in their side yard. You can see it there just adjacent to their cabana, which is actually labeled a shed on that plan. But it's very important that that be imposed as a condition in order to clarify that the intention with these development plans is to protect those regulated trees. And then with respect to the air conditioner, in my view, it is a very simple condition to impose, but the reason for doing so and the rationale in terms of relating it to the variances is that there is a north side yard setback variance proposed, and the intention with respect to the air conditioner location is to ensure that it's located in a spot that minimizes impact in relation to that side yard setback and minimizes impact with respect to noise, etc. So I do think it's related to the variances, and again, it would be shown on the building permit plans where that mechanical equipment is located. So it's a reasonable condition to impose and very easy to be cleared. And then with respect to the location of the fence, and specifically the restriction upon where it cannot be located, in my respectful submission, that is also something that is tied and related to that north side yard setback variance. It is also something that relates to mitigating the impact on the existing condition of my client's adjacent property at number 22 because of the location of their driveway, which is beside their dwelling. So again, I think it's a very simple condition that is easy to impose and easy to clear. And then lastly, the condition with respect to the building permit plans and ensuring that measures are included to avoid damage to adjacent properties. In my respectful view, this condition really acts as a flag to the building department to ensure that they take a look at this. And part of that rationale, in addition to what Mr. Bronskill has told the committee, is that particularly when we are looking at the south property at number 18, the existing driveway today is actually shared between those two properties. The paved area just sort of continues across the two lot lines. So when those grading issues are addressed, when the new driveway and retaining walls are constructed, that driveway will need to be cut at the property line, and we just want to ensure that the buildings department is advised to consider that aspect of it when they are reviewing the plans to ensure that there is no damage that results. I'll just close by saying that in my respectful view, these conditions are appropriate and within the jurisdiction of the committee to impose, and similar to other conditions that we have had imposed, particularly at the TLAB through private agreement and through consensus with all parties on board. And then finally, of course, we appreciate the willingness to enter into a private agreement, and our intention is that we will have a private agreement, both to include and also to supplement some of these terms. The concern from my client's perspective is that obviously the difference between having conditions imposed by the committee and a private agreement is that conditions are enforceable and remain in effect, notwithstanding property ownership. So it's for those reasons that it is very important to have them imposed as conditions. So subject to any questions you have, those are all of my comments. I'm happy to answer any questions.
The only question that I have, the only one that you've kind of maybe, I think may fly despite what the Deputy Secretary Treasurer said is forestry. So you're asking us to impose forestry conditions 1 and 2 for submission of a complete application for a permit to injure or remove a city-owned tree. That's number 1. And number 2 is the same thing for a privately owned tree. Is that what you're asking for in terms of a forestry condition?
That is correct. However, the language that we have provided in draft for the committee's consideration is to clarify that those permit applications will include appropriate measures to ensure that those trees are protected. And the reason for including that, as I'm sure you're aware, the city's tree bylaw, and particularly when it relates to privately owned trees, it authorizes the removal of healthy trees where the removal is required as a result of a development. So in my view, in my respectful submission, it's important to make clear.
I understand you have different wording. I mean, you heard what the Deputy Secretary Treasurer said before, that it's probably could cause delays for yourself, but we usually deal with conditions as they are stated. So I think that if we would even entertain putting a condition on, we would stick with what the standard conditions would be, which would be forestry 1 and 2.
Okay, well, I will say that would be better than no condition at all. My submission then would that the words remove be removed, and that it simply refer to an injury permit, because that would ensure that the intent is that those trees be protected.
Well,
which
it
is
says, it will be exactly what the clause says, which is a submission of a complete application for a permit to injure or remove a tree. That's what the way it's worded. So
well, thank you. My comment again is that it's preferred to have it than not to have it at all.
All right, thank you. Panel members, do you have any further questions? I think we've spent a lot of time on this now. So I think you understand the issues here. So I think we'll take it into committee then and have a discussion about this, because we're really just talking about a private agreements here and some conditions being requested. So what are your thoughts? I mean, I think we established that we're okay to put in that construction substantially be in accordance to the plans submitted. The rear third floor balcony, north and south sides screening be provided to 1.5 meters. Any thoughts on putting on forestry conditions? Mr. Nipfel.
I would agree with the proposal that you put before the committee, Madam Chairman. I think that a forestry condition that is a standard forestry condition, which if I understand correctly is number 1 or 2, is more likely to be to enforce than a separate wording. I'd be in favor of approval of the application subject to the condition about development in accordance with the plans, which was number 1. Forestry conditions number 1 and 2, notwithstanding the fact there may be problems, but the applicants have both indicated that they're in agreement with that. And the requirement for screening along the north and south edges. As Ms. Stewart indicated, it's not exactly what she and Mr. Brunskill had in mind, but I think it's better than no conditions at all. And I think that we're attempting as best we can to accommodate the concerns that have been raised and to ensure that the development as approved does not create a difficulty for adjacent neighbors.
Anyone else?
I would support that, Carl. I think that makes sense.
And then hopefully the rest, it sounds like the rest can be put into a private agreement. Mr. Clay, any thoughts?
No, nothing that I've already said. I mean, I have a great deal of respect for both councils' experience in this matter and their submissions, but I think we find ourselves bound a little bit by what we can and can't do, and I take Barb's perspective of, you know, what we should be making conditions on and what we should be avoiding for obvious reasons. So I would support Carl's motion. I don't know if it was a motion, Carl?
Yes, it was.
There you go. I'd support that motion.
Okay, so we have a motion to approve the application, including forestry conditions number 1 and 2, including a condition to construct substantially in accordance with the plans that have been submitted, and a third condition that the rear third floor balcony, north and south side screening to be screened to 1.5 meters. Okay, moved by Mr. Nipfel, seconded by Mr. Clay. All in favor? Okay, so the application has been approved with those conditions. And thank you, everybody. And the committee now stands recessed until 2 o'clock. 2:20?
Madam Chair, can we have 2:15 just to give staff a chance to?
Yeah, that's
go grab-
fine with me. Gives me more time to make it to get a sandwich too. Okay,
Yeah.
thanks.
And then anyone who's watching on YouTube, the afternoon session there'll be a new stream starting, so this one will be ending.
Okay, see you later.
Thank you, members.
Thanks.